So I have a quick update for you on the California magazine ban case, the assault weapons case, and also the ammunition restriction case, which are now set to be decided. So let's talk about this. As I mentioned in the intro, in this video, we will be discussing the Duncan v. Bonta, the Miller v. Bonta, and the Rody v. Bonta California cases. These cases are a challenge to the state's ban on so-called large capacity magazines, the state's ban on so-called assault weapons, and also the state's ammunition restrictions. A lot of you have been asking me what's going on with these cases, you've wanted updates on these cases, and now it's actually very important because all these cases are now set to be decided because all the briefs and all the responses have now been filed to Judge Benitez. This means that we are now going to play the waiting game to see how Judge Benitez rules in all these cases. Now, I'm not going to go through all the procedural history of these cases. If you want that, you can watch one of my other videos specific to each one of these cases that goes through all the procedural history and also the arguments that were made at various kind of segments of these cases. What you need to know for this video is that all these cases have made their way up to the Ninth Circuit prior after Judge Benitez originally ruled that the magazine ban, assault weapons ban, and ammunition restriction are in fact unconstitutional. In fact, the Duncan v. Bonta magazine ban case actually made its way all the way up to the Supreme Court. After the Supreme Court issued their decision in New York State Rifle and Pistol Association v. Bruen, all of these cases were remanded back down to Judge Benitez for him to reconsider the cases in light of Bruen. One of the primary reasons for the remand of all these cases was because the Ninth Circuit's prior use of the two-step approach and the whole interest balancing approach was expressly rejected by the Supreme Court. So essentially these cases had to be redone because prior the Ninth Circuit had got this wrong. So these California cases started over kind of, but Judge Benitez has tried his best to actually get these cases resolved as fast as possible. In the Duncan and Miller cases, the state of California made multiple attempts to try and push the cases out for as long as possible, often asking for mid to late 2023. Benitez rejected those attempts, but that did not stop the state of California from continuing to ask for even more time. All of this came to a head at the beginning of last December on the 12th, when all three of these cases, along with the Fotis Billy Club case, had hearings before Judge Benitez. What ended up happening is that at that hearing, Judge Benitez gave the state of California 30 days to present a spreadsheet of enacted laws and regulations which relate to the cases at hand. He then gave the plaintiffs an additional 30 days to rebut those examples. After that, he set a deadline for 10 more days for both sides to file their responses. So essentially, these cases were pushed out for at least another 70 days. Now, a lot of you have been asking, why did Judge Benitez do this? And really the best guess is because he's likely anticipating that there's going to be an appeal by California up to the Ninth Circuit. The state of California has already signaled multiple times that they will try to argue before the Ninth Circuit that there were procedural errors made by Judge Benitez. They will argue that on appeal, or that they should have been given more time and more ability to present expert witnesses, expert testimony, and additional evidence, which they believe is required under Bruen. I think Judge Benitez did this to try to mitigate some of those arguments that's going to pop up at the Ninth Circuit appeal. Also, Gavin Newsom and his office had already outright admitted that they think that they're going to lose these cases, that they're likely going to be struck down, so they're already kind of preparing for the Ninth Circuit appeal. Well, now the 70-day timeline is up. All the papers have been submitted to Judge Benitez, and now we are essentially playing the waiting game to see how he will rule on these issues. Now, I'm going to point out some of the interesting arguments which were made by the plaintiffs in their recent response in the Miller case. There are also awesome arguments that are made in the Duncan and Rody cases, so go check those out as well if you're interested. In the brief, plaintiffs argue first that California is simply putting forward a renewed call for interest balancing, which Bruen invalidated. They state, claiming that this case somehow requires a more nuanced, analogical approach, defendant's brief sidesteps the directive of this court to focus on relatively analogous historical laws, and instead attempt to simply repackage means-end interest balancing scrutiny instead of following Bruen's required text as informed by history approach. But these are issues that have already been litigated and defendants' efforts fail. Bruen did not open a door to litigate Second Amendment challenges under interest balancing tests, which the opinion expressly disapproved of. Defendants, apparently aware of how little constitutionally relevant support they have for their AWCA, that's the Assault Weapons Control Act, seek to apply a more nuanced approach in precisely the wrong way, as Bruen only suggests such an approach with regard to the determination of what constitutes a proper historical analog. The plaintiffs here go on to state, the defendants attempt to revive interest balancing by claiming that a more nuanced approach means looking beyond their non-existent historical support and taking us back to the policy reasons why the characteristics prohibition by the AWCA are not actually used or needed. But this they cannot do. Heller settled this question in the context of handguns, and the American people have overwhelmingly chosen the AR-15 and similar semi-automatic firearms for all manner of lawful purposes, including but not limited to self-defense. By posing and then using cherry-picked data to answer their question of whether assault weapons are frequently used in self-defense, defendants are simply reframing this case into a policy question. Does the average citizen really need an assault weapon? But the premise of their question was already rejected by Heller, which ultimately held that it is the choice of the American people and not their governments which settles the question. So those are strong arguments being made by the plaintiff. Shout out to John Dillon, their attorney there in the Miller case. He does amazing work. I always really enjoy reading his paper, so strong arguments there. And then in the next section, they completely shoot down the state's arguments for why they need an expert and why an expert is needed to make the historical analysis they believe is required under Bruen. In this section, they point to the fact that the Supreme Court, in reviewing Bruen, didn't call on experts to decide that case. Instead, they simply looked at the legislative facts and relevant history on their own to conclude that the New York law was indeed unconstitutional. So California arguing that they need history professors and other experts to essentially look at this issue is simply not true and not even consistent to what the Supreme Court did in Bruen when they decided that issue. Finally, the plaintiffs point out that the state's best historical example, which they claim justifies the assault weapons ban, actually doesn't even justify it at all. California tried to use a 1771 law which restricts people from setting up trap guns as a basis to justify their assault weapons ban. But the plaintiffs point out that that best law that California is presenting, at the very least, is a restriction on conduct and never was actually a ban on possession of the various firearms in question, and also wasn't even a ban on accessories, which is at issue in the Assault Weapons Control Act. The plaintiffs state, the prohibition that the defendants held up as their strongest support for the AWCA was a ban on conduct, the setting of a trap using a firearm, not a prohibition on the possession of a dangerous, unusual weapon or any particular set of characteristics. Thus, the defendant's best and most analogous historical law to justify the AWCA is both distinguishable and far from sufficient justification for California's unconstitutional ban on common semi-automatic arms. So those are some of the interesting arguments made in that Miller case in the recent brief. I recommend you go check out that brief and also look at the Rody case as well in the Duncan case. Some very strong arguments have been made against the state of California, but now all the briefs are submitted, the time is up, the clock is out, and now we will play the waiting game to see what Judge Benitez ultimately rules. The decision could come very fast for those I'm likely expecting or asking the question, like, how fast can this happen? It could happen fast. It could also take various months. No one really knows. So for everyone who's been asking what's going on in all these California cases, that's a quick update. If I get any more information, if we get any decision from Judge Benitez, of course I will let you know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.